everyone is ready. So welcome to round 6. Open government BPPA, open opposition Bishan, closing government back and fast, and closing opposition esoteric. Okay. So on the motion, this House believes that Supreme Court justices should adopt original meaning theories when interpreting constitutions, and the Prime Minister to come to somewhere and deliver his speech.
Yeah. If judges are going to interpret a constitution in the context of the present time, the interpretation is going to change far too quickly for the constitution to have any valuable meaning. If human dignity is to be interpreted according to the modern context of the time, it allows every single judge to decide what human dignity means, whether it means upholding religious freedom or whether it means upholding the freedoms of individuals' sexual orientation. Two things in the speech panel. One, why consistency in law is good and the 3 advantages that stem from consistency. And second, why originalism is more democratic as a principle and why we care about that principle. First thing then, why is consistency good? The first advantage is because that consistent law is fairer law. Judges aren't always going to agree on what reasonable people at the time of the Constitution was made believed either. We agree with that. But the test of what the reasonable man believed when the Constitution was formed is a far stricter test than the test of what the reasonable man today believes or tomorrow will believe. There's plenty of tools that you can use to provide evidence of what people believed at the time the Constitution was formed. It's a very literalist theory, right? Originalism, which means you take words as they are given, or you can use dictionaries that were used at the time, debates made by founders of the Constitution in your country to see what they believed in, why they thought a particular provision had to be included in a constitution. That is, there's a limit. Is there a clarification? No, cool. There's a fixed set of literature that you can refer to ascertain what the reasonable man believed in when the Constitution was passed, or what the founders thought. And there is a fixed range of reasonable assumptions that you can make about a Constitution according to that test. That is what your legal precedent is based on. And contrast this with what opposition has to defend, which is how the meanings of Constitution changes rapidly according to the context of its time. That means precedent is overturned by reinterpreting laws all the time. The US, because the Supreme Court has the primary power to strike down laws, has the highest rate of overturning laws, one of the highest rates in the world. The ability of judges to interfere in what constitutions mean, according to their own preconceived biases and predispositions, rapidly increases on their side, because the way to interpret what a word means in the modern context differs so much, right? Do you think religious belief should be upheld, or do you think, no, in fact, it is sexual orientation, which is far more important to human dignity? Those kind of things, the literature for both sides is far more widespread, far more diverse, and often there is no consensus agreement in modern times as to what particular words and terms can mean. No, thank you. Second thing as to why consistency is good. Consistency is more predictable. This is particularly important when it comes to commercial law. You need to know how valid a contract is and the extent to which it is going to be upheld in the court of law. The reason English contract law is the most popular in the world is because of its consistency. Because remember, predictability is what leads to economic growth. An example here. Recently, the Supreme Court of the US overturned precedent which said that if you are an online retailer which does not have a local office in a particular state, you do not have to pay taxes there. They overturned this, saying you have to now pay taxes in whichever state that you are doing online business in. That drastically overhauls the tax structure of hundreds of companies in the US, right? In a single day, because a high court judge was feeling like making economic policy, decided to make bankrupt a couple dozen companies and individuals because they can no longer overhaul their tax structure and their business was just designed in a very different day. On opposition, they have to contend that economic laws can be changed in a way which only a government should be allowed to change it, such that individuals can go bankrupt based on which side of the bed a judge woke up on. Third thing, judicial activism is reduced on our side. What laws mean today is not, it's always going to be inherently subjective on side opposition. A well-meaning judge will always want to do the fairest thing. But just because they are well-meaning does not mean they can leave their biases and predispositions and prejudices at the door of the courtroom. They can come in and still have their own, the way they were socialized, the way they believe things, right? An intuitive example here is how two different judges may perceive an African American to be. One individual may perceive that individual to be more likely to be a criminal or guilty, while someone else may think they're more likely to be a victim and an oppressed minority. That is a kind of bias that often affects even Supreme Court justices when it comes to individual cases, right? The greater the flexibility you have on side opposition in interpreting constitutions, the greater room for justices to interfere and make law as they wish it to be so. Before I go on to my second argument, closing, do you have a POI? Opening?
The paradigmatic originalist decision is DCV Heller. Do you think that was a good decision?
Is what, sorry?
DCV Heller.
Don't know what it is. Whatever. But I mean, yes. Okay, look. The point obviously is that there are some bad court decisions on our side. I mean, I gave you 3 examples of bad court decisions on your side. Do you think they were good? Presumably not. Yes, there are going to be bad decisions on our side and on your side, but my first point about consistency was that it is fair because it is a limited way in which justices can interfere in and of themselves. But you know what? Fine. To what extent can you change constitutions on our side? Because that's the comparative, right? The comparative is not just originalism versus changing norms. It's originalism plus plus additional ways of altering and amending constitutions versus just letting judges do what they want. So the first principal point I'm going to make here is that constitutions are only as good as the system they are based on, right? Constitutions are a democratic way of safeguarding minority rights. But on their side, no matter who you think ought to decide what goes in a constitution. No matter what you think a constitution should be, you sure as hell don't think it is 9 random old justices who should get to make the decision of what goes into a constitution. But you do on their side. On our side, you can change a constitution, no thank you, by either passing an amendment through parliament, or you can have a referendum. They're going to come back and say it's impossible to change a constitution in the United States of America. True, but it is incredibly easy to change the constitution in the UK or in South Africa, where all you need is a 51% majority. So the ability to change constitution is on a spectrum. So that's going to be a wash either way, so they can't push that burden. The thing about non-originalism, about why it is principally wrong, regardless of the country it is based in, is because government gets its legitimacy from the people, not from justices. The government's laws should be based on what people believe, and it should respond to those changing beliefs, but in a way that reflects that through government changing, right? Which is why constitution should be democratic. But crucially, the best case argument that we're going to get from opposition is, aha, you fixed yourselves into this conservative social norm. Unfortunately, on their side, all you ensure is that the court can be liberal for a particular period of time till the moment the Supreme Court is stacked with a conservative set of justices whose predispositions are different from the ones you think are correct. So any liberal change that you may get on your side for 20 years is going to be overturned the moment majority of the Supreme Court justices are conservative. And this is why Roe v. Wade is likely to be overturned when Trump gets to appoint the 9th replacement of Justice Kennedy. It is because you did not go through the proper procedure and have the buy-in from people, but simply forced through cultural change, imposed it on a society that wasn't already willing to accept it. For all those reasons, propose.
So in DC and Heller, what happened was that the conservative judges adopted an originalist interpretation of the Second Amendment, casually ignored the word militia, and then used that as an excuse to unravel the regulations on the possession and ownership of arms. It was not the most accurate approximation of what the Founding Fathers thought of that amendment. It was a fig leaf for the conservative judges on that bench to push through their conservative predilections. And that's the problem with originalism. It is not literalism that exists on its own, where you look at the words and you look for the meaning of the words and take its natural and ordinary meaning. Originalism takes that a step further, where you imbue these words with the intention, or you try to approximate the intention of the Founding Fathers when that clause was drafted, and then apply that to the facts before you. We don't think that that principle should apply anymore. I want to deal with a few rebuttals first. Let's talk about this whole concept that things should be as consistent as possible. Look, under company law, okay, I just got to clarify this. The only reason why English contract law is so popular is because they colonized half the world. But apart from that, right, let's talk about the provisions under company law. Things like offer and consideration, offer and acceptance, things like consideration are concepts that are relatively settled. There is not much negotiation to be had with regards to those terms. When you're talking about things like human dignity, when you're talking about things like equality, when set in a context where swathes of people have not been considered human beings or have been precluded from the electoral process or been systematically disenfranchised, these are terms that are constantly in flux that have to be consistently and constantly clarified to the interpretation of the judges. But let's deal with another point here. Let's talk about whether or not is judicial anarchy coming from our end. No, it's not. The very concept of things like stare decisis ensures that there is a level of consistency that goes on. But let's go beyond that, right? When the Supreme Court looks at the decision, it considers many other things. It looks at all the decisions that have been considered by judges in the district courts or the appellate courts below. It looks at things like the extent of the legal arguments forwarded by counsel representing each plaintiff at a point in time. It looks at things like facts forwarded by expert witnesses at that point in time. There are many restrictions that come into play that limit the kind of interpretation that can come through. That's the whole point, because we also acknowledge that the judges don't want judicial anarchy to go through because it affects how people can regulate their conduct going forward. We don't think that stands. But let's tackle judicial activism as a concept. They would want us to believe that judicial activism will be addressed if you were to push through originalism. That's not, if originalism was taken out. We think that's nonsense, right? Judicial activism exists on both ends of the spectrum and will continue to exist on both ends of the spectrum. Let's use Justice Kennedy as an example. He was put into the bench ostensibly as a conservative justice. But then when you look at how he basically tried to embark on this judicial activist like rogue adventure with like Planned Parenthood v. Casey, where he went off tangent and decided to push through what he thinks ought to be law, we can clearly see that judicial activism is going to be rife anyway. Their policy does not address that. But at the very heart of it, we think consistency will be achieved even if you don't have originalism. Let's talk about why my substantives. Why exactly is this a deficient interpretive principle? It locks in the political arrangements at the point at which that particular article was drafted. It locks in the power structures and the biases of that given point in time. That's why if you look at the US Constitution, African Americans were considered 3/5 of people, and it required Abraham Lincoln to sneak in the 13th Amendment to change that conception altogether. It took 100 years for that to change. We think that when you're talking about founding values, right, we think it doesn't make sense why the same founding values that were existed at a particular epoch should remain the underpinning values for the rest of time for the given country, especially considering that at the point at which that clause was drafted, not everybody had a seat at the table. What we want to do and consistently ensure is that everybody, as time goes on, gets that seat at the table, and what we need to happen for that to take place is to abandon originalism. Secondly, judges are terrible historians. Granted, when it comes to determining the intention of the founding fathers, lawyers will bring in expert witnesses and historians to interpret what happened at that point in time. But both will provide their own expert historians, and then ultimately the judges will then look at the expert evidence that's been put before them and find a way to try and rationalize the kind of interpretation or narrative that will best fit the political message. And then they say that's what the founding fathers of the United States would have preferred at that point in time. We've seen things like Boynedin versus Bush, the case about habeas corpus, where all the conservative judges tried to rationalize this as a value that existed throughout time and wanted to remain consistent and filial to that perspective, when really the concept of habeas corpus, especially when it came to Guantanamo Bay, had to be considered in its time, right? And we think that's massively important. Now, why do we need to abandon originalism? Because we think people deserve to try and push and acquire rights through many ways. Through the ballot box is one way, but we think the courts needs to be another viable avenue for them as well. Because right now, let's look at the context that we have, right? We have an increasingly conservative government that's willing to go around whatever the judicial decisions might be. For example, Boynedin versus Bush. Once it was outlawed, right, the holding or detention of people at Guantanamo Bay was deemed to be unlawful. What did the Obama administration do? Took everybody and shipped them off to Bagram. So what you're trying to do is that you're facing a government that is increasingly making inroads into the rights of people, and at the very least, you don't want the judiciary to be the bastion for all these conservative ideals as well. We think what we would much rather do is that they abandon that and be forced to explain why exactly those outcomes ought to be justified. But sure.
The moment you allow the courts to be an open battleground for different cultural beliefs, you result in the polarization of the Supreme Court, at which point they are no longer fair, impartial ascertainers of what the law is, but simply deciding what their cultural beliefs are and imposing them on the
But a side that exists already anyway, right? The only problem is, through originalism, you give them the sheen of legitimacy to allude to the founding fathers and say that this is one of the underpinning values of the country that should remain. We think that's disingenuous. What we want them to do is to come out and justify why they think those people should be unlawfully detained and not make vague allusions to the founding fathers, but rather take the argument by the horns and push it through. We understand at some point in this debate, they're going to make the argument about backlash, that people are going to push back against judicial activism. But we're fine with that, because as Roe v. Wade attests, the moment rights are acquired, it's much harder for you to roll back those rights that have been acquired by people. Rather, let's look at the nomination of people like Kavanaugh and Barrett. The discussion now comes out is, how exactly are they going to limit the extent of Roe v. Wade? So we think there's a positive that we want to cling on to, and something that makes me extremely proud to oppose in this debate.
We could have an extremely boring debate in which we ask each other increasingly obnoxious POIs about cases that the other side is unlikely to have heard of until I make up one that does not in fact exist and see how the opposition deal with that. But the reason that would be pointless is because this is not a debate until we find the most liberal case, the one that we all feel most comfortable with in terms of the outcome, and decide that that is the side that we support. This is a debate about institution building, and it's about how, in a value-blind sense, if we don't know objectively what the best outcomes are because we live in a democratic society and believe that should be decided by the people, how best to apply law in a fair way which gets the right outcome and the intention behind that law is upheld. That is the objective when you design the way that people should be interpreting the law. It's not so that you get the outcome that you personally want in one case, because that will always backfire. 3 questions in this speech. Is originalism inherently conservative? Secondly, I'm going to ask the question about judicial activism, and finally on what gets a better constitution and better laws. Is originalism inherently conservatism? I think it's conservative in the best sense possible. It limits the role of the court because it upholds the principle of the separation of power, that the court should not be a primary law maker. Why is that crucial? It's firstly crucial because it prevents the abuse of power. It prevents people selected there non-democratically from usurping the functions of the democratic system. And secondly, it prevents the abuse of that power in case that person is biased or influenced in some way, given the small number of people in the courts. In the US, it is true that originalism is associated with Scalia, Thomas, and Gorsuch, who are more conservatives, and to some extent with Roberts and Alito. But I think what's important to note is that the Israeli Supreme Court, the originalism applied in that context, has supported the rights of Arab Israelis to a far larger extent, because when that constitution was originally written, that was extremely important. So we can push all of their examples about how you get more left-wing decisions with originalism in a different country's context. So I don't think that was ever going to be the important thing that decided this debate. Because they were like, in DC versus Heller, they ignored militia. This was an outrageous burden push by opening opposition, who suggested that we had to defend the worst pseudo-originalists on the US Supreme Court rather than the principle itself. This is the debate which was very clearly defined in the info slide as the interpretation of what a reasonable person would have decided at the time. They decided to offer their own interpretation of what the motion meant, ignoring the fact that the CAs have very conveniently provided one for us. And so, ultimately, we don't have to defend originalist claiming judges, we have to defend the philosophy behind it. And I would suggest, if you've got a dictionary from around the time, militia does not include random dudes who are alone in their houses, able to buy as many guys as they want. That would seem like an implausible interpretation of that clause. I agree. I don't think any of us here are going to think that that Scalia was the best judge that has ever sat on the US Supreme Court, but I would point out he was a biased person who did not uphold the principles of originalism. For this to be a meaningful debate, we need to decide whether the principle is in and of itself good and assume that people will follow it through in a good faith fashion, because on their side they could get conservatives who aren't originalists who would do exactly the same thing, and this debate would quickly fold into pointlessness. This is not about the exact intention of the founders, it's about an interpretation of what the reasonable people meant at the time. That is what was important. They had a couple of more responses. They said, well, the problem is that stare decisis ensures there's already a degree of consistency within the system. The problem is stare decisis and non-originalist forms of interpretation are in tension, because for you to believe that previous courts decisions were right implies that you don't think that the grounds on which a decision was made ought to alter over time. People agree you should depart from stare decisis when you think that a decision was wrongly made, but unfortunately if you have a liberal attitude towards this and think that words evolve over time, you will change decisions as you think those words change, which is exactly what happened in the case when the definition of what a state was and what counted within the state, which was changed to mean, websites count as part of that state too. That was what screwed over these these businesses. It was Assad told you consistency was important. That never got a response. Finally, they said, looking at the facts locks in these decisions. I think they ignore the fact that constitutional courts are not in the business of looking at facts. Those have been decided by lower courts. They're looking at the question of constitutional questions, which always revolve around the interpretation of a word. We were the ones who showed you that you could provide evidence as to what people thought at the time. You can't provide evidence as to what you currently interpret a word to mean, because the interpretation of the word militia was quite obvious at the time, but now it's very unclear what a militia means, given the development of war and the fact that militias don't exist, because it sounds like it's from the 17th century. So that was on the first point. It is good that they are conservative in a sense. Closing.
So I think I was slightly uncharitable overall. The point about pseudo-originalism is that it's easy to happen because of interpretive ambiguity. So judicial activism is century more technical. Very good symmetry.
Sure, absolutely. That is my next point. Judicial activism. Open opposition say this happens on both sides. I think the important question in this debate is not whether it happens on both sides. I agree it will, but on which side is it easier for it to happen? And there are two structural reasons we think it is harder to do it under originalism. The first thing, there is a smaller range of reasonable outcomes for exactly the reason that Assad gave you. When you have to interpret something and you have to explicitly provide a justification for why that is what a reasonable person at the time thought, you're doing that from someone else's perspective and you have to provide evidence for that. You have to say, these are the small range of things that person could have thought, and this is the evidence that shows that's what they would have thought. The comparative is, when you have to say what would a reasonable person think now, they can use their own interpretation of it. That's why you consistently see 5-4 decisions in the Supreme Court, which is just based around what that liberal judge thinks that word means. Look, when I read Obergefell versus Hodges, as a gay man, I was I was absolutely ecstatic that marriage had been extended. The justification itself was terrible. It said that due process within states means this has to be applied across all states. As a lawyer, it was an awful piece of reasoning. That could not have been made under originalism because you could not have argued that the words in the Constitution meant that. And for the reasons that Assad gave you, even when we get decisions that we as liberals might like, that wasn't the most important thing in this debate. Finally, they said that the judges are bad historians. I just don't know why this is true. They're quite smart people. They can read this evidence. That just seemed to be a joke, substituting analysis. Finally, on whether you get a better court. Because the final thing they said is it locks in biases. This was why we provided in Assad that is a reason for having easier change of constitutions. It's quite easy to change the constitution in South Africa, for example, and that's generally upheld to be a better international model than the US. There are clearly problems there, but you'll notice just because a problem exists does not mean that this is the solution. The solution was not this, because this was an anti-democratic way of improving the constitution that was just based on what 9 people thought, rather than having a proper mechanism through Parliament in which these things might change. That was a much more important principle and a way to do this. The final thing they said is, this is good because people can acquire rights in the future. This just assumes that liberals get on court. There are plenty of conservative forms of interpreting the Constitution that are not originalist forms. So they just seem to assume that if the originalists didn't get on, that more liberals would get on, and more decisions that they like would happen. In terms of minorities acquiring rights in the future, that again folds back into the response of, yes, we would like that, but this is not the way to do it. Ultimately, when you're building a value-blind system, you have to do it in a way in which you don't just assume the people you like will get onto the court or the decisions you want will happen. You have to apply the fairness of the law. That is the principle behind the court, that's the principle behind equity, and that is why we were so proud to propose in this debate.
Okay. What they disdainfully term obnoxious use of examples is actually being grounded in facts, because they know that the weight of history is not on their side. They may be able to raise 1 or 2 instances where originalism led to half-decent outcomes. But historically speaking, when you talk about Dred Scott, that determined that African Americans are not fully human under the United States Constitution. We will deem all the decisions throughout American history that deem LGBT individuals to not have the right to be who they are. When you look at Heller v. DC, which led to the abolishment of all restrictions on handguns, historically speaking, originalism has always been a tool for the powerful to block the ability of groups to use either the democratic process or the court process to obtain rights for themselves. And whilst a living constitution may be messy, historically it led to Brown v. Board of Education. It led to the abolishment of Jim Crow. It led to the rise of gay marriage. Even if there are exceptions, the weight of history is not on their side. I'm going to look at 3 things. Firstly, legal theory. Is this good legal theory or not? Second, the democratic process and whether or not their alternative of how the Constitution should be democratic is a viable alternative. And thirdly, the idea of backlash and overturning good decisions. First and foremost, legal theory. Now, let's clarify once and for all. Right? A living constitution is not a judicial free-for-all. Some judges may abuse the process, but by and large, judges still have to follow legal formulae, build precedents, look at expert evidence, look at precedents from other jurisdictions in order to conceive and evolve the rights in a constitution. One example, right, the right to equality in the United States. When it was first conceived, it was merely in terms of citizenship. Jim Crow laws were still very much constitutional, and there was no intention to abolish Jim Crow laws. It took over 100 years for judicial precedents to build, to them to gradually find that the right to equality also means that separate but equal is also a bad thing. There is a judicial methodology behind this. It is not free for all. But we admit that things do get a bit political because we are talking about rights, and rights are nothing if not political. And that's where they are not sensitive to what Imran said, that originalism isn't some neutral avenue through which rights are entirely apolitical. It's just a means for people who are already in power, who are more involved in the establishment of the constitution, to lock in their preferences for all time and make it virtually impossible for anyone else to get a seat at the table. And we don't think that a set of privileged, mostly men from a century ago should have the right to fetter the political rights and actions of future generations in such a way. To put it simply, historically, even if you look at India, oftentimes it's the privileged that rely on things like property rights in the Indian constitution to prevent economic reforms by the Indira Gandhi government over and over again. So yes, they may raise a Hawan Barak, which is an exception even in the Israeli Supreme Court, where the Palestinians get virtually no rights under the Israeli constitution. By and large, the chances are the powerful use originalism to their advantage, to which they then say we shouldn't politicize the court, ignoring the fact that even if we were to step away and give the court over to originalism, that does not mean that the powerful will step away. The powerful are always there. The powerful are always looking to appoint the next Scalia, the next Robert Bork, the next Gorsuch, in order to ensure that their policy preferences are written not just into law, but into the Constitution. Lastly, they've never engaged with what my other speaker, maybe later on, told you, that judges are eminently bad historians. If we are to view that judges cannot access medical evidence and require expert evidence, the same applies to history. We would rather they adjudicate things like rights as opposed to reading historical texts and attempting to come to a conclusion based on absolutely no expertise whatsoever. So this idea that originalism is the best legal theory is fundamentally blinkered. Next, let's look at the next issue. They say that the democratic process is a preferable route and the constitution should be democratic. That is fundamentally wrong. The constitution is meant to be undemocratic. It is meant to fetter democratic action by ensuring that 55% of the population cannot take away the rights of the other 45%. And this is where my substantive comes into play, maybe later, which is that the democratic process is a bad means through which underprivileged minorities can gain rights. Firstly, because it is principally wrong to ask an LGBT individual to go before the voters and say, look at me, I'm a human being and you must treat me like a human being. A constitution should already treat that person like a human being to begin with without them having to go before the voters. But secondly, oftentimes the democratic process is captured by the powerful who have access to media, who have access to who do not have the same collective action problems that people who are poorer and less privileged will have, and therefore their preferences, even if they're in the minority, are often written into law. But thirdly, issues of human rights, especially of minorities, are often important but not electorally determinative. Even if you believe that gay marriage is a good thing, you might care more about your economic situation. You might think that the Republican Party is better for you economically, and you ignore your preferences for gay marriage. So we don't think a democratic process is necessarily the fairest way through which rights are obtained. 1 second. So the comparative here is no rights versus some rights. Those rights may be contested, those rights may be controversial, but at least they're there, and at least minorities get to enjoy them. You disagree?
Most liberal reforms passed through judiciaries require operationalisation through the executive. If they do not have a popular mandate or a popular backing, how well do you think that will go?
Chances are, if you manage to appoint 5 or 6 Supreme Court justices, there is some popular backing for Brown versus Board of Education. So like, when Brown versus Board of Education was first implemented, like I would think like 55% of America was for it, 45% was against it. So there were elements of the federal government that sent in troops to Alabama to protect the rights of black girls to attend white schools. Those government actions are eminently possible. But even if you have no executive support, the fact that that's where my next point comes in, the idea of this being overturned. We think judicial decisions are often the way through which you build political support. To put it simply, it is easy to oppose rights when you're talking about them in the abstract. When rights are never there to begin, when those rights are never there to begin with, and you can fearmonger about it to say that once gay people are allowed the right to marry, for instance, then the institution of marriage will be decimated. It is only when rights are given to begin with, in the face of backlash, and over time people realize that maybe having gay marriage hasn't destroyed my marriage to begin with, hasn't harmed my children, that the opposition will melt away. So it's not a straightforward process, right? Sometimes people may want to go through the democratic process, but if they go through the court process, it is often beneficial as well. The paradigmatic example here is Obergefell, the gay marriage decision. America was arguably split in half when the decision was implemented. But in record time, not a single one of the justices that the Republican Party is looking to employ right now are even considering overturning Obergefell because the political support has been engendered after those rights were given. We're not saying that each and every instance of this is going to happen, for instance. Roe v. Wade is currently under danger. But by and large, this is a tool that activists who are fighting for their rights should be allowed to have. And therefore, we think that it is better that people have avenue to appeal to the judiciary in order to obtain their rights as well, thereby destroying the point. So at the end of the day, right, we acknowledge that there may be a bit of subjectivity here, but all judicial interpretation of the Constitution is always subjective, even under the world. Our world affords rights to those who did not have a seat at the table, and for that, I'm immensely proud to oppose. Thank you.
We know it's very popular in debating to take a liberal case and run it hard, but we're going to do something quite remarkable in this debate and take an old school liberal approach, because we're going to tell you that smaller, more accountable governments lead to governments that are more representative, that make longer lasting political change, and that ultimately uphold the rights of minorities. But before I do that, I just want to tidy up a few points in the opening half. And the first point I want to talk about is the reference to slavery by OO. Because they were like, it took so long to change the Constitution, like what if we had slavery earlier? Imagine what would have happened if the Supreme Court ruled in favor of slavery 100 years earlier, when not anyone in the North even supported getting rid of slavery. That would have led to the Civil War, except 100 years earlier with no support. What we tell you is that our methods might take time, but when they happen for good. And I'm going to talk about that more later. Second, they told us about this great judicial methodology, where judges take a very long time to piece together all the different puzzles from different decisions and come to a brand new meaning. We think that's just crap on stilts. Like, essentially, if judges just go through a whole lot of decisions and like, yeah, everything's just evolving, like the text has just evolved so much over this time, you're not actually taking reference to what societal changes have happened. You're just taking the random reckons of politically appointed judges over time and then aggregating them to the outcome you actually want. And we think that given Trump has promised to replace Kennedy with someone who will overturn abortion law, we think that is exactly what they're going to say, the same thing. A great judicial methodology. Yeah, right, more like a political appointment by Trump who's going to find someone who has the judicial methodology to get to where they want to go. That was not a good point in this debate. So, just one last point actually. They talked about the Bush electoral decision. Part of our case is that decisions are better respected when they are made by a non-politicized court. We think the problem is that a whole lot of social issues have been decided by courts, and they've come down on either liberal or conservative basis, which means no one has confidence in the Supreme Court. We think the Bush decision would have been way better in a world in which everyone accepted his, like, this, what happened in the votes in Florida had been done by a non-politicized court that just stuck to the letter of the law. We think that would have been accepted by Democrats and would have saved us a whole lot of heartache for 15 years as people questioned whether or not their president was basically a con artist. So why do we support smaller, more accountable government? Smaller, more accountable government is better. We think that what that does is it makes it closer to the people it represents and stops the overreach of the majority. So, what has happened? Historically, constitutions really restricted the rights of big governments, right? They said that we'll have a basic minimum for all the different states of whatever country you're talking about, whether it's the US or Australia, to come together and be joined by a government. And they put very strong restrictions on what the federal government could do. FDR in the US deliberately appointed judges who would overturn that position so we could massively grow the executive. He literally threatened judges to try and get his friends in Congress to fire them if they did not uphold the laws that he got his friends to sponsor. That led to the massive enlargement of central government and meant that local governments were really constrained. I've got a whole lot of reasons why this is a problem. First, we think there is not as much of a connection between a representative at the national level and a representative at the local level. So at the national level, a representative is whipped by their party. They live in Washington, D.C., for example, which is a highly politicized environment far away from the actual constituents. A local person lives with their community, and there are a lot more of them, right? We think it's unfair that Nebraska, which might have a rich and diverse set of voters, only gets 2 Senate seats, each of which are elected by the majority of voters in Nebraska, right? The problem is that when a law is decided, now since most laws are done at the federal level and not the state level, all of the liberal voters of Nebraska never get to submit on that law or have their say, because that debate happens at a national level and only the majority gets that decision. We think that that makes laws unpalatable for the people who end up getting them and just stops them from being able to participate in the process. We also quickly remark here that Trumps and other populists like Strom Thurmond in the 1970s and 80s had promised to drain the swamp. We think there's been created an enormous amount of resentment towards federal government because people think it is out of touch. That wouldn't have happened if we had original decisions which stopped governments from getting big and was strong on like the rights of states to be limited to just the specified matters in the Constitution that the president could do. Second, we think that social policy is poorly decided by courts. A, because it's not connected to those people, but B, because it has no access to information. Opening opposition said, oh, you get all these great submissions from both sides on like all cost-benefit analysis. Exactly. You get 2 sets of submissions, both from people who are on opposite ends of the spectrum, and they get to carefully curate what the court hears. It would be far better if governments and everyone in society could comment on social issues, and we could get thousands of different perspectives, not the 2 cherry-picked by the particular litigants in one case. We think that's a terrible way to make laws. We think it leads to bad outcomes. Yeah.
How would George Wallace and the racist Alabama government put into practice Brown v. Board of Education?
Well, they did put it into practice, which is my next sentence, right? So when a judicial decision happens, this is my third mechanism, judicial decision happens, the state hates it. No one got to vote on it, and everyone resents the government. So what they do is they make the most ridiculous Jim Crow laws, which push the boat up way further than the general decision of the court. Because remember, the court can only say treat everyone fairly, but can't say how to do it in all circumstances, because it's not right in the legislation. So states deliberately push the boundary of what's acceptable until they get to a position where the court accepts it. And there is no cost on George Wallace to put the most horrific Jim Crow laws in place, because you can't, like, the Supreme Court can't actually sanction a government, right? So that's why we see issues like abortion, which happen when no one accepted it, get ridiculous regulations put in place in them, which makes it functionally impossible to get an abortion. And because there's been no political compromise that agrees that we can get an abortion in different states, people continuously enact them until they're struck down, which essentially undermines the purpose of them in the first place. For civil rights, we just point out that an originalist position never would have allowed things like stop and frisk under the unreasonable search and seizure laws. At first instance, those decisions were allowed because as our constitution understanding changed, they said, we've now allowed these things to fall in within reasonable stop, search and seizure. That never would have been allowed under an originalist position, which would have protected rights which unfairly harm minorities, because it's black people in urban areas that get harmed by stop and frisk. We think an originalist position would have upheld smaller government civil rights. Finally, majorities. We think it is terrible that executives are largely elected by majorities who tend to be middle class and white. That is how George Bush was elected. That is how Trump was elected. That's how everyone is elected. The people who implement the policies at a national level are middle class and white. And they don't implement policies in a way that helps black people or minorities. We think that wouldn't be true if, say, the state of North Carolina, which is predominantly black, or the city of Baltimore were passing its own laws regulating its own people. We might get things like divorce law a lot quicker. We got divorce law really quickly in those states and it spread. And we think that is the best way to implement those decisions where they're more connected to the people, in this case minorities, we're proud to propose.
I think the people who wrote the constitutions are probably fairly well-meaning. I think they probably had great intentions in mind when trying to shape the future of a country. Unfortunately, countries tend to change and evolve, just as the people within them do, just as the mindsets of the people within them do. I'm going to be talking about an extension, democracies, constitutions, and the franchisement of individuals that will forever be left out of this process. A lot of the rebuttal to the government bench is going to be interwoven. Before that, just a few quick pieces of extraneous that I want to deal with. The first thing is what opening government says. They say, if the Constitution and like the originalist interpretations don't really agree with you, you can always change the Constitution. It's very easy in places that are not the United States. If this is the case, then as OG characterizes, it's not clear that you avoid the kinds of flip-flopping and the lack of consistency that it characterized as being the worst possible outcome for the law. Because if it was really easy to change the Constitution and people are going to do it all the time, all of their harms are still going to flow from that. But second of all, I think it's really important to note that parliamentary systems tend to uniquely disenfranchise minority individuals who are unable to access these. So it's not, again, not clear that they're able to get the kinds of benefits they want on their side. The second thing is something that closing government said. They said, so this is a question of local governments. They give a lot of reasons why local governments might be better than big governments. This is probably true, but the unique link they don't prove is why constitutions always work to restrict the rights of big governments in comparison to local governments. Note that most of the examples from the US, which is actually quite unique in terms of how it treats big government powers and in terms of how the country was set up, I think in most places in the world, you don't get the kinds of protections that you want against the powers of big governments. The last thing I want to note here is the manipulation of the judiciary and how this is going to lead to things like judicial activism. First of all, I think non-politicized courts are a bizarre thing for closing government to want to stand behind, given that politicized interpretations of originalist constitution text is something that happens all the time. So you aren't going to have a non-politicized court. You're merely going to have a more polarized one, where every single side is able to stand behind that decision by saying, it wasn't really my decision, it wasn't really my politics, it was the interpretation of a constitution based on historical fact that led to this outcome. I think this actually allows individuals to distance themselves from the bad outcomes that they're trying to push into place, because after all, it is not they who are racist, it is the people who have written up the constitution and demanded that certain things be done in certain ways. Right, so on to extension material, and a lot of this is, again, going to deal with the government material. I want to start by examining the fundamental premise of most societies that we are talking about, most of the democratic societies with constitutions, probably fairly liberal. The premise of society is this: if you do no harm, you should not be constrained by anything other than what you have control over. We think it's the accidents of race, class, gender, and birth are ridiculously arbitrary, and the reason we think so is because you have no control over the space in which you were born. Similarly, we don't think it's defensible that people should be constrained by the unhappy fact that they were born 200 years after the Constitution was first drafted. We don't think this is any different from any other accident of birth, and that if individuals have no control over what is governing them, then simply put, they should not only be governed by it. What do constitutions do? Again, the people who drafted it, probably quite responsible, probably quite well-intentioned. Crucially though, we had no control over what their thoughts were back then. We lacked the opportunity to consult them, to raise our concerns, and to argue for our own points of view. For many of us, no thank you. For many of us, we lacked the ability to even be considered full persons at a point when the Constitution was written. To be ruled then by a law that we have no control over, to surrender our property, our rights, and our choices to people that we will never meet is tantamount to a form of bondage that is antithetical to the basic principles underpinning constitutions, which every single other team in the round has agreed is to protect the rights of individuals that would otherwise not seek to get the protection we have. This is principally wrong on a number of levels that I have just enumerated. Here are some practical impacts that flow from it as well. No thank you. First of all, I think you get the massive disenfranchisement of people that will never see their points of view represented within a constitution. To say nothing of how legal institutions are set up, which are tremendously white and middle class and male. No thank you. I think you get you get no system of checks and balances on a constitutional system in a way that you get over an electoral system. What are these kinds of checks I'm talking about? Again, for many countries, judges tend to be elected, so there are at least some kinds of democratic processes that you can put on them. Even if they're appointed, again, there are political processes that you can attempt to engage in. All of these things are more accessible, even if you're a minority, than trying to access the thoughts of somebody that lived 100 years ago. No thank you, in a time when you were not yet born. I think this is actually tremendously important, right? Because it allows individuals to have slightly more faith in the judicial system as one that is able to represent them and represent their thoughts. No thank you, something that I have slightly more control over. On a second practical level, no thank you, I think constitutions are inherently regressive and backwards looking. What does this mean? It means that when you constantly consult a constitution, you are attempting to move back to an idealized golden age of a time that never was. If you look at the slogan, "Make America Great Again," no thank you. It implies a time when America was indeed great. I think a constitution actually has much the same effect, because you are looking back to somebody in the past and considering them to be experts of a time where society was probably slightly more expertly set up and going to provide better outcomes for the rest of society. I think all of this means that you are unlikely to see any kinds of progressive impacts on the side of government. Closing government tries to get around this by saying, but progressivism actually isn't the largest goal. We agree with that to a certain extent, but we think that if this is the case, then you should allow individuals to have control over it rather than delegating control to a system that you have no control over. Opening.
Look, constitutions, when they're originally implemented, require a massive process subject to a number of checks and balances. You want to replace that with 9 arbitrary people who decide on a given day how they think that it's feasible to understand.
I'm sorry, if the comparison is white middle-class people today in America versus white middle-class people in 1800s America, I'm going to say it's going to be slightly less arbitrary now than it was back then. But even beyond that, I think, again, first of all, you have 9 Supreme Court judges. Not all of them are going to be interpreting it in the same way. That is at least one level of checks right there. I think on a second level, the legal system is getting increasingly more diversified as more and more minorities are able to go to college and go to law school. Third of all, I just think on a comparative level, again, the trend is towards liberalism. We cannot allow the myth of a golden age in the past to be something that we return to, especially when it provides little ability for us to check back against it. Last of all, I want to talk about constitutional history and what parts of it we can actually access. Opening government says we can consult historians. I think opening opposition says this too. But what I want to bring to your attention is the idea that we only have access to certain kinds of testimony, that even if there is a fixed and specific literature we can consult, we will always only have the Federalist Papers, and we will never have the testimony of Thomas Jefferson's mistress, Sally, who was a black woman living, again, in 1800s America. I think all of this means you never get certain kinds of views represented, you never get certain kinds of experiences represented. All of these things are better. Even if 9 judges are arbitrary, they're still better than what we used to have.
At the end of the debate, the major question that we have is how do we create enduring, positive social change and enhance the well-beings of our society? And it's notable that the team in this debate that brought the material that best directly addressed that question was us. Because we said when you're asking about how to create positive social change, you need to analyse the state as an institution and ask how that institution will evolve over time within the constraints of the Constitution and how that Constitution is applied in practice. And we gave you considerable reasoning that was never addressed by our opposition as to why originalism will generally result in a smaller state with more clearly enumerated powers and more local decision making, which is positive for social change. We also explained to you that the decision-making of a judiciary to intervene needs to have a popular mandate and legitimacy, because you don't want a backlash, but you also want the operationalisation of that change to be done in a way that isn't toxic and corrodes that change, while locking in a sense that the battle has already been won. Again, material that Josh gave you that wasn't responded to by that side of the House. So my whip is going to be relatively straightforward. I'm going to talk about firstly the opening half and the bickering backwards and forwards about are there good judges, are they bad judges, how do you do it, is it possible to do it well, and clean that up relatively straightforwardly. Then I'm going to talk about the manner and nature of the state and how that changes dramatically when you have an originalist interpretation presiding over your constitution and why that is highly beneficial for the actors that have been discussed in this debate. And then finally I'm going to talk about how you get improved social outcomes, and that's where I'll talk a lot about legitimacy and mandate setting. So let's firstly talk about then, can good originalism be done? We're kind of inclined to agree with our opening half that historical inquiry is something that can be done. That there are lots of expert historians, the founding fathers wrote copious notes about everything, it was literally the only hobby they had for like the majority of their life. And it is also notable that over a period of time you can build a corpus of understanding about what that originalism meant. The great thing about originalism is that you have 200 years to work on the same problem rather than constantly reiterating the debate about what the current social situation and policy adjudication is. Also remember the comparator, right, which is the epistemic complexity of making a historical inquiry versus trying to adjudicate a policy debate when you're a judge who's probably a big reader of history and literature but not a very good policy maker. That's why you don't work for the government. That's something we think is new material, which deals with quite a bit of what came out the front. But further things to say is that a lot of our mechanisms about reducing state overreach and depoliticising the judiciary, which that side of the House agreed was a consequence because they were worried about a reduction in judicial activism to help minority groups, is that law inherently becomes lower stakes. So you have more time to nerd out as a judge and just focus on like increasingly technical and esoteric interpretations of the past because you don't feel a pressure to decide in the right way, in a way that will be palatable to the political discourse of
of the time. You're not being forced to do something you're not good at, which we think will structurally result in better judicial outcomes occurring on a regular basis. Also, you'll appoint judges who are better at like originalism, so we expect the quality of originalism to increase over time as you decrease the politicization and the stakes there. The next point that came out of closing, which I thought was like this great new extension, was that apparently there are like epistemic limitations on what you can know about the past, and that's really bad because there's like a fixed amount quantum of history to study, right? Like, there's a lot of history, right, which is quite a copious amount, but also like courts have a really limited epistemics around how much expert testimony they can receive. And Josh gave you analysis that wasn't responded to, that they received two very slanted interpretations of policy issues rather than like a robust and technical interpretation of the historiography, which we think is more likely to occur when it's like judges always have epistemic limitations, right? But we think a narrower historical inquiry is more likely to be able to be engaged with by judges. They were then like, it's backwards looking inherently. We're like, yes, that's what we like. We like the fact that the constitution and tradition and a shared understanding of the nature of enumerated powers within our state does look backwards. That's what causes it to have legitimacy and buy-in from the people. That was extension material that I'll cover later on. And the final thing they said is that it's just wrong ethically for you to be bound by law you had no role in shaping. Like, heaven forbid that the activist court makes a judgment that stands for 100 years and is never revisited, which seems to have roughly the same problem that they pointed to, which is that precedents can also stay around for like 300, 400 years, and you don't have much say and influence over them, right? Also, like, all legislation, once it's more than like 20 years old, a significant portion of your population won't have been born when it was passed. So this point, while clever, I think was ultimately futile in being a useful way of adjudicating this debate. Right. Yes.
How do you remove politics from originalism?
Well, because like originalism essentially is going to be, well, firstly your side accepted it would be depoliticized because you're worried about a reduction in judicial activism, right? But the second thing is also like originalism will have fewer opportunities to make arguments that things should be changed, right? It will be a narrower fixed conception of the role of the state. And that means there's no point in having highly politicized judiciaries where you fight over those interpretations because there'll be fewer cases brought and basically people will recognize it's not a valuable avenue to be enacting social and cultural change, which we think was a benefit, right? And that's where the clash in this debate takes place. We accepted that there might be a reduction in judicial activism, but we thought it was a benefit because it was more sustainable change when it did occur. Right, now let's talk about the fact that the material that we brought that we didn't really receive a response to. So we said that obviously you're going to have a greater continuity and coherence over time in your government, which will build a popular mandate and cause people to have more confidence and trust in the institution of the judiciary when it makes decisions. That means they're more likely to avoid politicising that institution because they don't see it as a battleground for the day-to-day politics. You separate politics from the question of appointing of the judiciary, which we think is a really positive and proactive step to take. But you also have a government with more clearly enumerated powers that are more closely connected to the text of the Constitution. We think that it's state overreach that is often the way that minorities are the most victimised, right? It is a creeping regulatory state that infects more and more of the aspects of their lives and provides more levers for politicians to influence and support their favoured in-group versus their unfavoured out-group. We also think that you get more local accountability, right? Because you can't use the federal government necessarily as a lever to enact change. You have to drive change organically from a local ground up, either by changing hearts and minds and not requiring a state intervention, or by operationalising the state interventions at a local level. That's why it's interesting that divorce law changed, right? Because there was no like judicial decision to enact changes to divorce law, but there was an organic changes that happened at the local state level that then catalysed an observation that in fact the world was pretty fine when that happened, and that was something that goes on. We also would point out that, like, to the degree to which the government becomes inflexible because of the fact that the judiciary can't make these overreaching decisions, that will build bipartisan pressure, right, for constitutional conventions, because both sides of the House will build up a corpus of disagreements with how the Constitution originally was being interpreted as applied to day-to-day life. And that creates a bipartisan consensus that constitutional review is needed, so you can get your stuff in there, and then you have a new constitution, which is probably going to be modern and serve the test of time for at least 50 to 100 years. And we think a regular cycle of updating your social contract is just strictly preferable to trying to judicially decide policy outcomes on a case-by-case ad hoc basis. Finally, supporting minorities. I integrated most of this into my speech, but the main thing to note is that you need to, having an originalist position closely ties judicial decision-making to the national heroes and identity of the people, right? Because the judges are going about talking about the characters and the narratives and the identities of the historical figures. That means that the ordinary people kind of buy into it a little bit more because it seems to align with their own conception of how the Constitution originated and how the Constitution guides the founding principles of the state. We think that is a huge lever to drive legitimacy and mandate for this court, and that's something we think is a new contribution that should not be ignored. For all of those reasons, very proud to propose.
Side government has played a particularly nasty trick on us today. The key motivation for their case is in the words, 9 judges appointed for partisan political interests. I'm going to point out that the United States of America is not the only country in the world with a Supreme Court or a constitution. What they have identified is a specific flaw in one specific country's method of selecting judges, not a structural flaw in what the judge then goes on to do that's Anglo-centric in their case's focus. I'm going to look at 2 points in this speech. Firstly, I want to take out the closing government extension about governmental overreach. Second, I'm going to look at consistency and fairness, dealing largely with opening gov. So what do we have on closing gov in terms of overreach? There's 2 premises to this argument. The first premise is that constitutions enshrine small government. I'd like to point out, once again, this is an extraordinarily US-centric claim. It is true that some countries create constitutions that are built on principles of freedom, like a post-American revolutionary situation. Some countries build constitutions founded on the protection of stability. For example, many post-conflict states like Rwanda enshrine fairly wide-reaching government powers in order to preserve the protection of stability in those countries. So this first premise is just factually false, no thank you, in the majority of countries that aren't the United States of America. The second premise to this argument is, well, small government is healthier for politics because it means you feel more connected to politics. It means you're represented as a locality better than in the other case. Right. I wonder how, in that situation, we would be able to pass policies that say aimed at redistributing wealth away from richer localities, which requires a certain amount of governmental overreach. The point is not that we think progressivism is correct, therefore everything that's progressive is the right sort of policy. The point is that constitutions are often enshrined to protect the power interests of whoever was at the top of the hierarchy, including wealthy people who wanted their localities protected from that sort of redistributive action. Which really brings us to the second question then, about, broadly speaking, consistency and fairness and which side does better on that front. But again, let's just point out that on both of those premises, that CG extension is false. Not true in the majority of cases, it's small government. Even if it's small government, that's not a priori a good thing. Okay, consistency and fairness. The key motivation in opening government is that, it was the question they asked in the PM speech. What gives judges the right to decide what dignity is? Our question is, what gives people living hundreds of years ago the right to decide what dignity is? The principal claim we submit in closing opposition is that constitutions have normative power over our lives, over the lives of current living people. Judicial decisions made with respect to them license the state to use violence, to take property, to limit freedom. There is a requirement that we have power over who gets to decide what constitutes dignity in that situation. So that responds to the question, what gives judges the right? We think judges don't, in the majority of cases, decide whimsically. They're not all like political appointees for narrowly partisan reasons. Firstly, note that even in cases where they are appointed, it's not like we have no control over the political process that appoints them, right? Like, even if, your intuition that the US stacks the courts, if we democratically elect a Republican government that then chooses a justice who is conservative-leaning, that is a reflection of what people have nominated for via political process. But also, as Enting points out, in the vast majority of cases, this just isn't how judicial appointments work. In some cases, there are appointments that are made on meritocratic bases rather than for partisan interest. In some cases, there are direct elections that people have which give them control. So broadly speaking, this claim is false. Again, the question is, what gives people from hundreds of years ago that power to make choices for us? That is the principal threshold this prop must make, why our forebears should have power over our lives. What are the justifications we have from OG? 3 justifications. First, they say, consistency is fairness. Okay. Because of literalism, because there's a smaller range of reasonable interpretations. 2 responses. Number 1, we need to ask an important question. Why is it the case that there is a smaller range of reasonable interpretations? Because, as Enting tells you, the key problem with historiography is the limited historical perspectives we have access to that skew in favor of privilege. The response from closing gov was the assertion, well, it's a twofold assertion, really. It was mostly a dismissal. First, they said, there's lots of history, and second, they said, well, currently there are limited witnesses who can give testimony in court. All right. It is true there is lots of history, but who writes that history, right? It's not people who didn't have access to literacy, not people who were never interviewed because they weren't seen as important, not people who didn't have access to a printing press or who didn't have access to the ability to have their historical records transmitted down the line. The vast majority of historical records from which the picture of what a reasonable person would interpret as just is skewed towards people who had access to those sorts of facilities to transmit their views downwards through time. They say we have limited witnesses presently. That's true. It is more likely you get your input in a world in which you currently exist and your testimony will be heard than if you lived hundreds of years ago and your testimony was never heard because you weren't seen as important. How do you weigh this up? Opening opposition points out, I think this is correct and excellent, that people, these voices didn't have a seat at the table. They don't explain to you why the absence of a seat at the table back in the day means that their voices become currently absent from originalist explanations. Enting gives you that analysis. It's because of the historiographical method and which voices it leaves out. The second response to this is that, I'd just like to point out that it is really untrue that this is just about literalism, because the motion, the info slide didn't say originalism is about like just reading the words, right? It says it's about how reasonable people from the time would interpret it. That requires us to make extrapolations about motives, and that's why it's relevant which people's motives and beliefs are included in the interpretive set. The second reason from opening government was that it's more predictable this way. Just to be very clear, if you look at your notes, this argument was made specific to business interests and the advantage of business stability. Can I point out, this is the worst context for the opening government case, because the face of 21st century capitalism is radically different from how it looked 200 years ago. So like, it's a good thing for business law to evolve to accommodate that. This is just a silly context for the case to be situated in. Third, they said it's about judicial activism. Okay, activism is symmetric on both sides, given the interpretive leeway judges have. I'll take opening in a second. We think the problem, activism is worse on their side because of the veneer of legitimacy you get when you can abdicate moral responsibility. If you say, if you want to pass it, I'll take you in a moment, if you want to interpret anti-discrimination law as extending to bathroom bills or not, that means that you now have the ability to say, but it's not my moral responsibility, it's what the founding fathers thought was true or false. Yeah, go on, Hassan.
Making a constitution is a key form of nation building. You need all groups, or as many as possible, to buy into it. This means constitutions aggregate protections for groups better than random judges appointed for large groups.
No, thank you. That's false. They aggregate preferences of a specific class of people who were dominant hundreds of years ago. Okay, the final argument we get, I think this is an interesting pushback from the Gov bench, is that we need public buy-in for a law to be enforceable or to have lasting power. Two responses. Number one, that assumes laws don't have signaling power and can't set the agenda for the future, right? As opening opposition points out, or sometimes we just need to enforce the law, like we need to enforce our constitutional changes using the arms of the state. Over time, it becomes normalized as a practice. But secondly, this is very important. They are right that public enfranchisement and buy-in is critical to make law function. Ernting explains to you why this disenfranchises large portions of the population. Countries change, demographics change, people immigrate and people emigrate. Originalism licenses backward-looking attitudes that say, you're not really American. That's not what our founding fathers thought Americanism was. That leads to the precise disenfranchisement that diminishes the power of the law to enact its normative force over us, and it makes that law stop being just. Very happy to stand in opposition.